who came up. I went over the Blum. I said to Megan the next time I go to, so I already been over to him, and he was always, you know. So today, I saw him passing me. I didn't recognize his ass, and he said, "What are you doing?" I said, "Are you still looking at all that construction? If you come to work, those are my bills. Remember, those are my bills."
Got him a lot of attention.
I told him it was envy, you know. I don't think we'll be hearing from him again.
Got him a lot of attention.
Yeah, but not the kind
That
he
he
likes.
wanted.
He was there by one vote.
Rules Committee will come to order. We're going to go ahead and proceed despite one of our witnesses not yet appearing. Today, the Rules Committee will consider H.R. 4901, the Scholarship for Opportunity and Results, or SCORE Act, and H.J. Res. 88, disapproving the rule submitted by the Department of Labor related to the definition of the term fiduciary. H.R. 4901, the SOAR Act, authorizes $60 million in annual funding for education in the District of Columbia, equally distributed to District of Columbia Public Schools, District of Columbia Public Charter Schools, and the District of Columbia Opportunity Scholarship Program. For more than a decade, the Opportunity Scholarship Program has given some 6,000 students in the district the ability to attend the private school of their choice. H.R. 4901 continues the emphasis on educational quality across the District of Columbia and brings opportunity to those in need, who are most in need, by providing them with an option and a means to attend private school, matching an individual to a better education. I want to specifically thank Mayor Browser and the District of Columbia City Council for their support of this initiative. I think it's admirable that the mayor and the council recognize the needs of their people, their constituents, and the needs of people who they care deeply about. In particular, I want to single out the mayor's staff that are here at the Rules Committee today. Both Tomas Tomatic, I'm going to muck them all up, Tomas, I'm sorry, and Roberta Downing, is that better? Have worked to support this legislation, are aware of the impact, and they have come to a conclusion and agreement that it will improve the education of all students in the District of Columbia. Thank you for taking time to join us here today. I know you're interested in the success of this piece of legislation, and you will be here to watch us as we try and further this effort to help you, to help your students, to give them a better opportunity. The Rules Committee will also consider H.J. Res. 88, disapproving and nullifying the Department of Labor's rule published on April 8, 2016, related to the definition of the term fiduciary, and the conflict of interest rule with respect to retirement investment advice. Every member of Congress has heard the outcry from their constituents on the fiduciary rule, which would impose a host of costly new mandates and burdensome regulations on financial advisors that provide retirement advice. H.J. Res. 88 directly benefits the many families and small businesses that rely on the assistance of trusted financial advisors to help lay the foundation of a secure retirement, one that would be in their future. I would like to welcome today the young chairman from the Government Oversight Committee, Chairman Chaffetz, and Delegate Norton. I want to thank both of them for being here today. I'd also like to ask that anything you have in writing to provide our awesome stenographer will be entered in the record without objection. She appreciates it. She does speak Texan, but is struggling with Utah lingo sometimes. So, Jason, you do feel free to leave that for her. And, of course, will be submitted in the record. We look forward to your testimony. Before we go any further, I'd like to defer to the ranking member of the committee, the gentleman from Massachusetts, for any opening statement you'd like to make. The gentleman's welcome.
No, I don't have an opening statement, but I always feel uneasy that it seems that we're meddling in D.C. in the internal affairs of the D.C. government, which I wish we wouldn't do. But there are a lot of things I wish. I wish D.C. had statehood. I wish they, Ms. Holmes Norton, could vote like everybody else because she works just as hard as everybody else. But that's a long discussion. But I wish we weren't doing this. I'm not happy with this legislation. But I'll yield back to the gentleman, and we get on with this hearing.
Thank you very much. We will get on with the hearing. We do care about what people think, and I do understand what the gentleman's saying. This is an honest attempt to help students regardless of what party, and I thank you very much. Mr. Chairman, welcome. Gentleman's welcome. Do you have that mic on, green light?
I do.
Gentleman's recognized.
Thank you. I thank the chairman. Thank you for the opportunity to testify
before you on HR 4901, Scholarships for Opportunity and Results Reauthorization Act, better known as SOAR. It creates a three-sector approach to education within the District of Columbia, and the bill provides equal funding to D.C. public schools, D.C. public charter schools, and the Opportunity Scholarship Program, the latter of which is commonly known simply as the OSP. As you recall, I came before this committee in the fall to testify on former Speaker Boehner's bill, H.R. 10, also a bill to reauthorize the SOAR Act. The legislation successfully passed the House of Representatives, and appreciate Speaker Boehner and his personal passion on this issue for a number of years, and I'm glad to be able to help carry on that here in the House today. It's very similar to H.R. 10. However, after H.R. 10 passed the House, changes were made to it through a bipartisan negotiations with the Senate, and H.R. 4901 incorporates those revisions. Those changes serve to strengthen the bill by accomplishing three primary goals. First, they bring greater accountability and transparency to the OSP by increasing the reporting requirements for the OSP administrator. We had hearings in our committee. This was brought out. There was discussion in the markup, and I think it is a good enhancement to the bill. Second, they strengthen the accreditation requirements of the OSP, which were enacted at the end of 2015. Again, something that the delegate spoke about, as well as other members, and the need to strengthen that, which is now accomplished in this bill. And finally, they made clear congressional intent around the use of carryover funds and access to the OSP itself. So while the major substance of the legislation had not changed, I felt it was important to give members an opportunity to debate and vote on these changes. We did that. As a result, we reintroduced this bill. It's under H.R. 4901 as a commitment to regular order. And importantly, thanks to new improvements, that will make this bill, the OSP, even better positioned to build upon its strengths. And I have the rest of my opening statement, Mr. Chairman, but I know we also have a vote on the floor. I have actually put in my card and voted, but I'd be happy to answer any questions, and I would suggest I enter the rest of this opening statement for the record.
Thank you very much. In fact, what we're going to do is when the clock gets to 0, we will quickly, as soon as that happens, all go down, subject to us coming back to the end of the last vote. So thank you very much. Ms. Norton, welcome. John Williams recognized.
Thank you, Mr. Chairman. I feel almost apologetic to have to come before you again. This bill's already passed the House. As Chairman just said, there are no substantial changes in the bill. I also feel gratified to hear such solicitousness regarding the mayor and the city councils, considering the countless number of times I've been here to keep you from overturning the will of the council and the district and then the mayor. And I will have something to say about their support in a moment, because I wouldn't want you to think that I did not want to speak to that. As I said, this matter is going to be in your 2017 appropriation bill. It's the only way it's ever gotten passed. The Senate has never had an up and down vote on this bill. They started on this bill, had a hearing, and had to pull the markup. This bill was enacted in 2004 and 2011 on an appropriation bill, never been fully authorized by the Congress. If you look at what you did on the Elementary and Secondary School Act, you'll understand why. Because there were voucher-type amendments on the floor, and they were all voted down. The single voucher funded in this Congress is the District of Columbia. Of course, we in the District of Columbia, and here I know I speak for the city, would hope that the hard work of the parents and residents is what would be recognized here. It is true that the mayor and the city council wrote, and you should look at that letter. It's a bare majority of the council. And essentially what they say in a carefully crafted letter is that this bill is important to us because it supports our public and charter schools. It never says a thing about wanting to make sure we support the voucher schools. It is true that they have baked $20 million per sector. They baked the $40 million for the public and charter schools into their budget. They don't want to see the hole in it. What they most fear is a bill by Cruz and Meadows that is even worse. It would simply dip into the fund, say anybody from the District of Columbia who wants to go to a private school, take the funds from the District of Columbia and go right on. They mention that bill as saying that that is even worse, and they fear that even more. So they understand that the $40 million is conditioned upon accepting of the vouchers. I offered an amendment, the president said is also for the amendment, which would have allowed those children in presently in the voucher schools to continue until they graduate. But as you know, no amendments work in this Congress. The interesting thing is I'm hoisted on my own petard, because when this bill first came to the Congress, I said, why are you not supporting the great improvements in the D.C. public schools and the D.C. charter schools? Why are you giving it only to one sector? Bless his heart, the former cardinal of the District of Columbia said, give it to all three sectors. That's the only reason that the public and charter schools are funded. So I understand in the spirit of compromise why the city doesn't want to lose the money. I know perfectly well that as this bill was always reauthorized on appropriation, will happen this time. You know full well the Democrats will not vote for this bill. And so I understand the position you are put in. Last time, there were virtually no amendments on this bill. I understand that 11 amendments have been filed on this bill, and I support all 11. Thank you very much, Mr. Chairman.
Thank you very much. We appreciate it. I would say to both of you, but in particular Ms. Norton and the members who represent the mayor, I in no way think we're trying to put our finger in anybody's eye. What started 10 years ago is a good idea. We felt like it was good enough to include the money and the idea, not to tell you what to do. And I quite honestly may or may not have ever pushed this myself, but it's a good idea, and if it works, it's good for people. I'm not sure I would know, even after these years, a name of one person that has helped. But one thing I do know is I've been told that many, 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 many more people apply than are accepted. And that tells me there's something there. And if I were one of those parents who wanted my child, who Bill Sessions has known since he was in 5th grade that he wanted to be a doctor, and today he's at Texas Tech University Medical School, and he put his mind to it, he went to a private school also. He told me he did not think he was getting exactly what he needed in the public school. My wife and I sacrificed, put the money. He's in medical school, and he is going to take a Hippocratic oath to help everybody. And it may have been an education from a private school, it may have been an education that he received some benefit, or that they do here in D.C., but I do know that a child that wants to better their education and a parent who matches that dream, even if it is a gift from someone else, that child had to apply themselves to study. They were not given that. They may have been given an opportunity, but they had to study, and for that, I think that's pretty powerful. Thank you very much for being here, both of you. In no way do I hope that this action that we're taking is seen in a way, nor by having the mayor have two people here in any way other than we're just simply trying to help people by giving them the money. Thank you very much. Dr. Fox?
Thank you, Mr. Chairman. I appreciate our colleagues being here, and I've heard Mrs. Norton on other occasions speak about this bill. I appreciate her representation for D.C., but I do think that the facts speak for themselves on this legislation, that the students who get the scholarships and go to the schools that they choose do better than the students who are just going, who are placed in schools by the city. And while I am not a fan of federal funding for education, that's not something I would do. I think in this case, we see results. And if we are going to spend money, and I think it's a foregone conclusion, I think that we will spend money on this program, the best thing to do is to know that we're getting good results. And so I support the legislation, and I will support the rule. Thank you very much, both of you, for being here.
This gentleman seeks your attention. Gentlewoman seeks your attention.
Mrs. Holmes.
I do understand the vice chair's remarks. I do, but I wanted to clarify, and I wanted to enter a bipartisan note if I could. I wanted to clarify that the results from the DC public schools and the charter schools show improvements, whereas the results in a evaluation mandated by this Congress show no improvements. Some of these children come right back to the District of Columbia. They go to Catholic schools. They're put right out if they don't do well, and we don't even have any sense of how many those are. I do want you to, the bipartisan note is this. Almost 50% of our children go to public charter schools. That started here in the Congress with Speaker Newt Gingrich when he wanted to do vouchers, and I said that there was a fledgling bill, and it had passed, and there were 1 or 2 charter schools. He built on that. I would challenge anybody on the podium to have as many as almost half their children going to public charter schools. And as the public schools themselves, in our city, 75% go to school out of their own district because that's how robust is the choice in the District of Columbia. And I know that public charter schools have had bipartisan support, and I certainly hope they continue to have that kind of support.
Thank you very much. I'm now going to ask that both of our witnesses please come back. We're going to be at the recess, accept the call chair, and we'll come back as soon as the beginning of the last vote occurs. Rules Committee come to order, and thank you very much for allowing us to have that vote series. Mr. McGovern, you seek time?
Yeah, Mr. Chairman, I want
Councilor
to
Arcanine.
ask unanimous consent to insert in the record the statement of administration policy, but...
Objection.
But I just want to read one line here that I think is relevant. It says, instead of using federal resources to support a handful of students in private schools, the federal government should focus its attention and available resources on improving the quality of public schools for all students. And I think that's where our focus should be. I'll just finally say, I really do not think we should be meddling in the, in DC's affairs as to how they run their schools and what programs that they should support and which ones they shouldn't support. That we ought to have enough respect for the people who live here and the people who are in government here to allow them to chart their own course. And with that, I yield back my time.
Thank you very much, gentlemen's comments are appreciated. Thank you very much. Does any other Republican seek time? Any other Republican seek time? Does not seek time. Thank you very much. Judge Hastings, thank you very much. I want to thank both of you for being here. This is an issue that will hopefully work in the benefit of students. District of Columbia, despite some beliefs that we've got. Thank you very much. If you'll please make sure you leave things for our awesome stenographer. Thank you very much. Is there any other member that would wish to be heard on H.R. 4901, SOAR reauthorization? Seeing none, this now closes the hearing portion of H.R. 4901. We would now welcome the gentleman, Congressman Phil Rowe and the gentleman Bobby Scott. And I don't see Mr. Scott yet, but I do see Mr. Rowe. Mr. Rowe, we're delighted that you're here. We love Eagle Scouts that come up to the committee and know that you're not only an awesome Eagle Scout, but a climber as well of mountains. And we're going to continue just for a second here. Mr. Scott's aware that we are proceeding. Mr. Scott is aware. Thank you very much. Dr. Rowe, we're delighted that you're here, and I see that the green light is on. The gentleman's recognized.
Thank you, Mr. Chairman. Chairman Sessions, Ranking Member Slaughter, and members of the House Rules Committee, thank you for the opportunity to speak today in support of HJ Resolution 88, a resolution expressing disapproval of the Department of Labor's rule redefining the term fiduciary. Retirement should be something hardworking men and women look forward to. However, today, too many low-income and middle-income families lack the tools they need to plan for retirement and obtain this part of the American dream. Instead of enjoying time with grandchildren or taking up new hobbies, many spend their later years worrying about how they will make ends meet. That's why it's important we as policymakers do everything we can to ensure working families are able to effectively plan for the future. An essential part of that effort is promoting common sense policies that ensure all Americans have access to quality, affordable retirement advice. Unfortunately, the Department of Labor's misguided fiduciary rule does just the opposite. Since the Department of Labor began this effort in 2010, concerns were raised from both sides of the aisle about the damaging effects these changes would have, particularly for small business owners and low and middle income families. Republicans and Democrats agree financial advisors should be required to act in their clients' best interest. That wasn't the issue. The issue was a proposed rule so expansive and complex that it would lead to harmful consequences that remain the issue, and that remains the issue today. Rather than protect the interests of retirement savers, the final rule issued by the department creates new hurdles for those the administration claims it protects. Under the new rule, small businesses will have to pay more to offer their workers retirement options, individuals will find it harder to receive basic financial advice, and low and middle income families, those most in need of help, will lose access to trusted financial advisors. These consequences workers and job creators simply cannot afford. Since the rule's initial introduction, our committee has held a number of hearings examining the consequences. The committee also put forward a responsible bipartisan alternative to ensure low and middle income families have access to quality, affordable retirement advice. It is imperative that we do not stand by and allow the administration to move forward with implementation of such a harmful rule. Under the Congressional Review Act, Congress has the authority to stop this irresponsible rulemaking, and this resolution will do just that. H.J. Resolution 88 will express Congress's disapproval and block the rule from being implemented. It sends a signal that while requiring financial advisors to act in the client's best interest is a worthwhile goal, any effort to do so should not put Americans' retirement security at risk. In closing, I'd like to thank my colleagues, Representatives Bustani and Wagner, who worked with me to introduce this resolution. Together, we in Congress can ensure that all Americans, regardless of income, can access the affordable retirement advice they need to successfully prepare for the years ahead. I urge the committee to support this resolution. Mr. Chairman, today, 29% of Americans 55 years and older have no retirement savings and have no defined benefit plan for retirement. They have nothing. And this 1,000-page rule, I brought the rule, and this is it right here. Does anybody in this room think this 1,000 pages, when you pour through it, is going to make it easier for people to retire comfortably? I yield back.
Thank you very much. The fiduciary rule is something that I hear about back in Dallas often. And it came up at a town hall meeting a few months ago. Really, this is a last year issue to me.
That's correct.
I did not know that the rule had only come out April the 8th, but I did know that it's been substantially discussed by a number of people for a long time. So I want to thank you for bringing this. It's literally one of the hottest issues back home. People who want and need help won't be able to afford it. Won't be able to afford it. Thank you very much.
Thanks.
Dr. Fox?
Thank you, Mr. Chairman. I spent time this morning with Chairman Dr. Rowe dealing with a different kind of an issue, but lots of issues coming up in our committee in education and the workforce, and this is one of them. I am one of the original co-sponsors of this bill and this resolution. I'm very strongly in support of it, and want him to know, I think he already does know it, but other people to know that what he's talking about is important. The ironic thing about this administration has been that it's so often the people they claim to be wanting to help are the very people they are going to put in a more disadvantageous situation. And I agree completely with Dr. Rowe. We have a lot of great people out there who spend their time helping others plan for their retirement with not much remuneration for it. But this is going to drive those people out of the market, and it's going to drive, it's going to keep many middle and low income people from getting any kind of financial advice. And the federal government's already made things so complicated that it's very difficult for anybody to plan for their retirement without some professional advice. And this is a real shame, this rule. It is going to have the opposite effect of what they wanted it to have. So I'm in full support of the rule. I'm full support of the great work that the chairman's done on this, and I have no further questions. I just say thank you.
Thank you very much. Mr. Scott, we're delighted that you're here. And I would allow, just before you start, Dr. Rowe, did you want to provide any feedback to Dr. Fox?
Just short, just to validate her point, this rule was passed about 3 years ago, almost exactly the same in England. And there's been a huge reduction in the number of people offering financial advice, about a 25% reduction in the number of financial advisors out there to help low-income people. And I actually and myself have been through this. When we started our medical practice, we had 4 doctors and 12 employees. We used we didn't have a fiduciary. We started our small pension plan this way. We've now grown our practice to over 450 employees, 100 practicing physicians. We have a fiduciary, we have a managed plan, and we pay a % fee to do it. That you can do that. When we first started, we could not do that. We would not have gotten started had we had this particular rule in place.
Thank you very much. Mr. Scott, we're delighted that you're here, and Dr. Rowe has provided his feedback. I would encourage you to do the same. Also, I did ask if you could please make sure that you leave anything you brought in writing for our fantastic stenographer.
Thank you, Mr. Chairman.
Gentleman's recognized.
Mr. Chairman, I'll just introduce my statement for the record and note that the administration has issued a statement of administration policy that points out that conflicted advice, where investment advisors essentially rip off their clients, costs American families an estimated $17 billion a year. The conflicted advice is where the advisor looks out for his own interest and gives advice to the client that will have excessive fees that in the long run would just cost the client money, when the investment advisor knows there are better products with potentially higher returns and lower fees than the products they're selling. Now, there is you get to listening to people, you get the idea that their business model won't work if they can't take advantage of their clients. Well, that's why the rule was passed. We're only talking about retirement funds, where you come in with your nest egg that you've earned all these years, and there's nothing wrong with requiring the person providing advice to have a fiduciary relationship, and that is to look out for your best interest and not look out for your own interest. That's what the rule does. The President concludes his statement of administration policy that if the President were presented with H.J. Res. 88, he'd veto it, that he would veto it. So that's where we are. I would hope that you would not waste their time and report the resolution.
Thank you very much. We're now in question period. Mr. Scott, Dr. Rowe suggested that there have been lessons learned or a report of information from what had happened in Great Britain 4 years ago. What did the Department of Treasury or those in the Department of Labor find that was advantageous out of that study that would offer some reason to offer duplicative
I don't know if they
advice?
looked, I don't know which study they looked at, but they found that there were plenty of people who are willing to provide advice with a fiduciary relationship, and all of the advisors can provide the same advice they're given now, so long as it's in the client's best interest. And if it's not in the best interest, yeah, some of them might have to stop working. That's right. That's why we
Okay.
have a rule. And
Dr. Rowe?
And like I said, some you get the idea that their business model won't work if they can't take advantage of their
So
clients.
they were only doing it to take advantage of people.
No, well, if the advice they're giving, if they don't feel that they can give it when they're required to have the best interest of the client at heart, that their advice is no longer any good, well, that says something.
I want to state a couple of things. One is this $17 billion is nonsense. How they came up with that number, I peeled the onion back. There are about 17, 18 trillion dollars that gets rolled over. You take 1% of that, and that's how you get 17 billion. There's no science out there that says this is the actual number. As a matter of fact, there's lots of data to show that's not true at all. But if you say it enough in this town, it becomes the truth. And look, I have actually done these things. This is not something, Mr. Chairman, I'm coming to talk about. I've actually seen these kind of products work in the real world. And I don't for 1 minute believe that the person that started our pension plan, his sole purpose in life was to take advantage of me. He couldn't live in a town of 60,000 people and do that, or she, whomever your advisor tends to be. There are models that work at certain income levels, and then I've changed that, and there are models that work in other income levels. And when we have a third of the population of this country that have no savings, do you believe that right there is going to make it easier to save money? I don't.
Dr. Fox, do you wish time?
I'll just make one comment in response to what Mr. Scott said. My husband and I had a very, very modest income 40 years ago, and we worked with a financial advisor. And I can tell you, we did not get ripped off. And I agree with what Dr. Rowe has said. You cannot live in a small town and go around ripping off your friends and neighbors and survive. How these good people are being characterized by this administration and by some of our colleagues on the other side of the aisle really offends me. And it ought to offend those people. And the only other thing I would say is I hear a lot about this too, and I've been amazed. It's not just the professionals in the business I hear from other people like us who have used folks to help them plan their retirement, and they understand about this. And it sells the American people short, which is, again, what I think this administration and many of you on the other side of the aisle do all the time. You sell the American people short, that they cannot listen to people giving them good expert advice and then make up their own mind what to do. You just sell them short all the time. And I think that's a travesty. You want government bureaucrats to run our lives from cradle to grave. I have a lot higher opinion of the American people than that. Thank you.
May I respond, Mr. Chairman?
Gentlewoman seeks the time. Gentlewoman, choose to engage the gentleman.
Well,
Well, I don't really want to engage
Okay.
Mr. Scott, but I
Mr. Scott is here as an expert
respect him.
witness, and we
That's right.
respect that.
It's
It's your
fine
engagement.
if he wants to respond.
I would just say that not all investment advisors are taking advantage of their clients, and if they are giving good advice in the best interest of the client, this regulation doesn't affect them. It's those who are, in fact, those few rotten apples who are taking advantage of people. Those are the ones that it's aimed at. Now, the original rule that was promulgated several years ago was withdrawn. The most recent one was offered and significantly amended during the process, listening to consumer groups, listening to investment firms, and the final version, the one that is now in effect, has been commented on by several of the major investment firms. And they have, they're showing that they recognize that this is significantly different than the original, and that they approve of it. And they have no problem, they don't have any problem with it.
Mr. Chairman, I just say that the folks who have come to see me, who are small-town advisors, are not rotten apples. They're good people, and they tell me it's not workable, and they are not rotten apples. I think, Dr. Rowe.
Just to make a couple of points. One, Bernie Madoff was a fiduciary, and a person who's dishonest is dishonest, and no amount of laws are going to make them honest. Do you have a model that will actually work? And not one single model works for everybody. If you took a 1% fee of one of my children when they started their 401ks of $2,000, you couldn't even manage the account for that. So I think to me, that's the problem. The other thing we did was in a bipartisan way, the Ways and Means Committee and the Education Workforce put an alternative to the Department of Labor, and they put earmuffs on. They didn't want to hear anything from us. They went right ahead with what they wanted to do. We were willing to work with them. On our side, in a bipartisan way, just our side of the aisle. And there's been a lot of Democrats who wrote letters about this 2 years ago. And it's only now that the president's really put the full court pressure on the other side that they backed off. They know this is not good for people in their districts too.
Well, I think there were many people, bipartisan letters written on the original rule. And the fact that they are now supporting the rule is evidence that there were substantial changes. And in fact, several of those are taking credit for the changes, and that's how the process works. You make your comments, the administration takes them into consideration. In this case, made significant changes, and the people that had concerns before don't have concerns.
Some.
And
Some.
exactly, some still have concerns, obviously, but and the original principle that if you're getting investment advice on your retirement funds, it's only retirement funds, not everything, just retirement funds, which often is about all you got, that the advice you get ought to be in your best interest.
Thank you. Judge Hastings?
Thank you very much,
Yes,
Mr.
sir.
Chairman.
Mr. Chairman, Mr. Scott referenced the administration policy, but I, at this time, would ask unanimous consent that it be made a part of.
Without objection, include that into the record.
Thank you. Let me ask Representative Scott, what does it mean for financial advisor to follow a fiduciary statement, and are other professionals required to follow this standard?
Well, I used to practice law. You have a fiduciary relationship, physicians. You can't give advice on what makes you the most money. You got to do what's in the patient's best interest. Most professionals have a fiduciary responsibility. This isn't anything new. And in this case, there's a lot of advice you can give to your clients, some of which will make you a lot more money than others. And some, the fees are higher, the returns are lower. And you know it's not in the client's best interest, but you know you can make a lot more money. And some of these products where their fees get significant, and you can do well for yourself and not for your client. And all this says is you just have to have your client's best interest at heart. And if you and it just raises questions. What's on the other side of the argument?
Yeah. How does this rule then compare, the final rule, compare to the proposed rule?
There are a lot of procedural things that were simplified so that there was some paperwork that had to be filled out, and it just became procedurally awkward. They smoothed that out so that the process is a lot smoother, but the fundamental principle that you have a fiduciary relationship was maintained.
Dr. Rowe, any further comments?
Judge, there were a couple of things that were changed. There's no question there were better. One was if you called up to speak to let's say you had Fidelity. I'll use them. They're a huge organization. And you called up and talked to somebody at Fidelity. You had to sign a contract with them when you made the phone call. And each time you called, you had to do. They backed off of that. They pulled that out, which was a good thing. There were a couple of things that were changed that were better. Our objection is this, Judge, is that low-income and middle-income people, you want to encourage them to save money. We have a retirement crisis we're facing in this country. People are living longer. Life expectancies have massively increased, so we need to encourage people. And the model that was out there is encouraging people, lower and middle-income people, to do it. For instance, if you put $5,000 in a retirement plan and you're charged a 1% fee, that retirement person can barely function that fee, fulfill his duties to that fee. Whereas some of them, by the way, I looked this up yesterday, I was studying a little bit about this, just because you pay a little higher front-end fee doesn't mean your earnings, your yield is not as good as someone else. I found in many cases that to be, in other words, a front-end load had lower operational fees and over the long haul made more money. So it is complicated, and what we don't want to do here is to make it harder for people to save. That's my motivation.
Well, I readily understand. I have sort of a disagreement, Dr. Rowe, with you and Dr. Fox with reference to small-town people. If I follow your logic, then the financial advisors in big towns, and you referenced Bernie Madoff, or the fast and swift that may be causing these harms. But some of the biggest crooks that I've come across have come from some small towns as well.
We're not immune to
we have
that.
a statement in the law, Bobby and I, swift lawyers have always been known, people will say, I'm going to get myself a Philadelphia lawyer. But every lawyer that I met in my practice that was from Iowa claimed to be a country lawyer. And they were some of the best lawyers that I confronted over the course of time. Let me add to the record and ask unanimous consent, Madam Chair, to include in the record the letter directed to me April 26th from a group referred to as Save Our Retirement, if that would be satisfactory.
Without objection.
And additionally, the Financial Planning Coalition, I would ask unanimous consent.
Without
that be
objection.
included. And I won't belabor
Mr.
the
Hastings.
matter, but I would cite to just the first 4 or 5 of them, including AARP, or the AFL-CIO, or the Alliance for Retired Americans, or the American Association for Justice, the American Federation of Government Employees, and there is a substantial list that are now a part of the record. And I will just extract a portion of what they say. The rule will at long last require all financial professionals who provide retirement investment advice to put their clients' best interests ahead of their own financial interests. By taking this essential step, the rule will help all Americans, many of whom are responsible for making their own decisions about how best to invest their retirement savings and keep more of their hard-earned savings so they can enjoy a more financially secure and independent retirement. In promulgating this rule, the Department of Labor engaged in an open and inclusive process, and the final rule is better as a result. Specifically, the Department of Labor responded to congressional and industry feedback by making specific revisions designed to facilitate implementation and compliance while minimizing the harmful impact of conflicts of interest on the quality of retirement investment. In the Financial Planning Coalition letter, they cite to the extraordinarily lengthy and transparent notice and comment process, which included more than 160 days of public comment, over 3,000 comment letters, and 4 days of public hearings with 75 witnesses. It just seems that a lot of attention was given to this, and there are those who are seriously opposed. Let me use a personal example, and like you all, most of us in Congress, if we are not of modest income, we go at the rate we're going without a cost of living adjustment, we're going to be at moderate income pretty soon. But on Monday of this week, I was dealing with an insurance policy that was written for me, my personal insurance, was written for me when I was age 51, and I'm now coming up on 80. The man who sold me that policy, his name will go unmentioned, but quite frankly was and is a friend. But at the time, if it were like yesterday, I remember sitting in my office talking with him and needing to rush to get to court. And I said to him, "Oh, just hand me the papers and I'll sign them." Well, I'm sure he didn't think, nor did the actuary think, that I was going to live as long as I did. And now I'm finding, when I really went into the fine print, that the policy is reaching a negative return, and I'm having to pay more as I grow older. So I asked them to do an illustration for me, which they did. And the question now, having put $79,000 into the $100,000 policy, whether or not I want to continue for a few more years to try to leave my legatees or something, or whether or not I want to try to save some of my money, because this thing is eating me up. Now, this guy was my friend, and I was from a fairly good-sized town, Fort Lauderdale, but he didn't mean me any harm. But as I was looking through the papers, I noticed, and I thought about this on Monday, I thought about how many of these policies that he wrote, and all of these years from 51 to now, he's still receiving his portion, albeit a small fee. Now, I think also that you and Mr. Scott would recognize that the area of Florida that I live in is one where a lot of people are taken advantage of by financial advisors, particularly widows and widowers who have moved to Boca Raton. We call it one of the fraud capitals of the world. And therefore, I personally just think that it's important that we have a fiduciary relationship with our financial advisors. Yes, Mr. Scott.
Thank you. I'd like to introduce for the record, we had a question about what changes were made. A four-page document going through many of the changes that have been made, working the best interest contract exemption, the plan advisors with level compensation, advice versus education, as more comprehensive response to the question that was asked. And also that your letter reflects representatives of workers and consumer groups. I'd just like to quote the head of Merrill Lynch Wealth Management, and they said, quote, that they were pleased that Secretary Perez, the Department of Labor staff, have worked to address many practical concerns raised during the comment period. The president and CEO of TIAA said, and I quote, based on our preliminary analysis, it appears that the department has gone a long way towards making the best interest standard the industry standard. And Morgan Stanley issued a statement saying that the Labor Department's final version of the fiduciary rules was, and I quote, meaningfully softened in several respects.
Right.
So it's not the labor and consumer groups that
Right.
were pleased with the transformation of the original rule.
And did you ask that that be made a part of the record, Mr. Scott?
It's part of my statement, so it's in the
Oh,
it'll
all
be in
right,
the
thank
record.
you.
Thank you.
One final request, Madam Chair. Richard Trumka issued a statement. He is the chair president of the AFL-CIO, and the essence of his statement is that he applauds the Department of Labor for getting the rule over the finish line, and other words that were positive. I ask unanimous consent that that be made
Without
part of the
objection.
record, and I
Without
yield
objection.
back the balance of my time.
Thank you. Mr. Woodall.
Thank you, Madam Chair. Thank you all for being here. Mr. Scott, I thought I understood you to say that if you were already acting in your client's best interest, right? There's some bad apples out there, but if you were one of the good folks that Chairwoman Fox was talking about in her community, or that Chairman Rowe was talking about from his community, that this new 1,000-page rule wasn't going to have any effect on you at all. Did I understand that
If
correctly?
you're giving advice in your client's best interest, then you don't have anything to worry about this new rule.
So there are no new paperwork requirements for any of these folks
There may be
out
some
there?
new paperwork requirements for disclosures, but you have no concern if you're giving advice in your client's best interest.
So all the products that I'm selling today will still be available to me to be sold under this rule?
If they're in your client's best interest.
Well, I see you shaking your head, Chairman Rowe.
No, I will disagree with that, because we've agreed from the get-go that you should look after your client's best interest, and that's one of the things in the bipartisan bill that we put out there, Mr. Congressman Woodall, and we agreed on that. That's not what we're talking about. The business model it takes for this to work, it's going to make it work for maybe clients that you used to represent. It will not work with this. It hasn't worked in England. If you just look at what happened in the country of England, the Merrill Lynch's, hey, listen, and full disclosure, Merrill Lynch manages some of my money. And so I'll give you that full disclosure. It doesn't affect me one bit, because I pay 1% fee, and whatever they do, they do. That's not the case for small investors. And that's my concern, is that the small investor just changed that business model for them. And young people that are trying to get in and begin to save for their future may be hindered by this. And I cannot believe that anybody would say that not going through all of that's not going to add cost. And we all know who ends up paying the extra cost, the consumer.
Well, to be fair, Chairman Rowe, reading from the Statement of Administration Policy, the President says the final rule reflects extensive feedback from industry, advocates, and members of Congress, and has been streamlined to reduce the compliance burden and ensure continued access to advice. So that is apparently the streamlined stack you have there, not the original unwieldy stack. That's efficient. Mr. Scott, I'll have to confess to you, I confess to Mr. Rowe all the time, so he's already heard it. This is one of my biggest, this rule is one of my biggest disappointments in my 5.5 years in Congress. I know as you sit there, there is not a fine man or woman in my district who dispenses this advice that you harbor any ill will for. And I know as Chairman Rowe sits there, there's not one person being cheated or defrauded out there that he wouldn't throw under the jail if he could get his hands around their neck. He led before you came in with the agreement, he said, we all agree that all of these folks ought to be acting in their client's best interest. I cannot imagine why in the world, on that basis of agreement, this thing that brings us all together, there's not a man or woman in this chamber who thinks we don't need to be doing more to save for their retirement. There's not a man or woman in this chamber who doesn't believe we should be doing more to help working class folks get involved in retirement saving, the power of compounding interest, the benefit of good advice. We're all in this together, and yet, when the chairman leads with, we all agree folks ought to do what's in their client's best interest, you continue not to use the fiduciary standard in your comments, but acting in the client's best interest in your comments. We're in this together, and yet it's the source of this bitter divide, and one that has to go to a resolution of disapproval. I have not gone through all 1,000 pages, I'll confess. That's what I love about the Rules Committee. The best and the brightest members of Congress come up here and give me a personal tutoring session before every bill comes to the floor. So since I have my personal tutors here, what is in this 1,000 pages that's going to throw Bernie Madoff further under the jail? If you're a fraud and a cheat, if you're stealing from your people who have entrusted you with their savings, what is in this that punishes you more tomorrow than we punished you yesterday? Because I do want to throw those folks under the jail.
Not anything in there that'll punish you more.
So if I'm a cheater today and I'm a cheater tomorrow, there's nothing in this that makes it harder to be a cheater?
The SEC has very, very stringent rules about how broker-dealers are managed today.
Mr. Scott, I guess that's...
If you're cheating and stealing, there are laws against that now. Those are easy cases. The cases we're talking about where it's not cheating or stealing, it's just conflicted advice. And it's a salesman. You could just sell people a product, not in their best interest. Now, when we say we all agree, one of the problems with the bill that was introduced was that it allowed unscrupulous people given conflicted advice to slip a disclosure in boilerplate language and essentially exempt themselves from the requirements. And it also had what is, in my judgment, unconstitutional provision that there's a congressional review before it can go into effect. Congress has to pass a law allowing it, and that the congressional veto has been long held to be unconstitutional. So there were problems with the legislation as introduced.
To Chairwoman Fox's point about selling folks short, I understand disclosures get hidden. I haven't read any of the, now I'm required to get that privacy notice every year in the mail. I haven't read one of them yet that's shown up in my mailbox, but it was supposed to make me safer to get them each year. If it's disclosed in there that my advisor is being paid by the people who produce the products, not by me, because he's giving me free advice and they're paying him, you're saying that's the kind of disclosure that is inadequate because I should be paying my advisor, the investment fund shouldn't be paying my advisor.
The disclosure could say that you are not, your advice may not necessarily be in your best interest, and you can word that in such a way that it looks benign. But you can disclose, if it's disclosed, and and like you say, you don't read it, I don't read it, and it's just part of the paperwork signed here. And all of a sudden, after you find after years that your account's been not drained, but just kind of nicked here unnecessarily, not in your best interest, then that's when you find out they weren't acting in your best interest, and you signed the form.
Tell me this. I have a lot of friends. Most of us, biggest investment we have is our homes, and a lot of folks retiring based on the equity in their home, and in some of these low interest rate terms with tough economy, folks are refinancing their home over and over and over again. They get more equity in it. They take more equity out, and what was supposed to be a source of security for them in their old age, they may well lose that home the way they're financing it. In order to protect those families, I could imagine that we might craft a provision that does not let folks take money out of their home in those kind of refinances, because it does threaten their retirement security. I think about some of the products that these folks are selling. Some of them have high exit fees. You can get into a program, but you want to get out of the program, you're going to have to pay some extra fees. I guess my question to you is, since we've all seen those families that have been harmed by sucking cash out before it was time to retire, if there's a really large exit fee on one of these investments that I've sold to a client, have I sold them something that's not in their best interest, since clearly there are lower fees available in the industry? I've sold them the high fee. Or have I done something that's in their best interest because I've created all of the incentives to keep them saving instead of have them spending?
I'm not sure about the particular question, but whether or not it's in their best interest or not, as Dr. Rowe indicated, you could have a fairly hefty front load that long-term is a good investment. Short-term is not a good investment. You just got, if you're going to hold it and sell it, kind of turn it over, it's a horrible investment. But long-term, so depending on your investment horizon, it could be a good idea, it could be a bad idea. But the question is whether or not it's in your best interest. And the investment advisor should be looking from your perspective to see whether it's in your best interest or not whether this product can generate the best fees, whether, I mean, you got just an S&P 500 fund.
Sure.
The results are going to be the same as every other S&P 500 fund, and some are selling them with huge annual fees and maybe even a front load. There's no way you can justify that as in your client's best interest.
There's just no question about, that. And again, that's why this is so frustrating to me. So many things, we'd come up here, and you and I, we just disagree about the way America ought to look, and we all love our folks back home, and we would just disagree about how to advantage them in their lives. But on this, we agree. We agree that bad actors ought to be punished.
Good.
We agree that working class folks ought to get a fair shake, and we believe that retirement security isn't just important, it's vital to Americans. And yet,
I appreciate your support.
we've punted on who gets to plan it. We've kicked it to the Department of Labor through a rulemaking instead of a statutory process, and we're sitting around here with lots of smart and caring people, and instead of us crafting a solution that we think is best, we're just arguing over whether or not we can live with the solution from 1600 Pennsylvania Avenue. I don't just think we're better than that. I know that we're better than that, and this should have been an opportunity for us to showcase the very best of the minds and the hearts in Congress, and instead it's just going to be another rejection of one vision and veto of another. With that, Madam Chair, I yield back.
Thank you, Mr. Woodhull. Mrs. Slaughter, I'd like to recognize you.
I'll be brief, but I must say that it's a little difficult to imagine. First, we would wait for statutory and any kind of relief in this Congress when we don't ever pass a two-house bill. Second, I'm somewhat perplexed as why we worry that people have too much information on how to do their job for the benefit of their consumers. Why, if $17 billion is lost to consumers every year, that's a problem, isn't it?
You want me to answer that?
Yes, I do.
If that were the right number, it would be, but it's not the right number.
And what is the right number?
Well, we don't know for sure. And let me
Do you
explain-
know
we
for
don't-
sure
we-
that 17 is not the right number?
I'm almost positive.
But not certain.
No, this is what they did. Do you know how that number is derived?
I'd love to hear your explanation.
The way the number is derived, they take the number of dollars that were rolled over, made an assumption that there was a 1% less yield if you roll that money over, and then that's how you get $17 billion. There's plenty of evidence to show that's not true. As a matter of fact, I can show you where mutual funds on the Morningstar from 2007 to 2013, where the front-end load did better by 27 basis points than others did. So it is complicated. What we do agree on is that you should look at the best interest. And look, I provided the retirement benefits for employees for 35 years in practice, over 30 years. It was paramount to me that when I finished my career, I wanted to be sure those folks that had worked for me all those years could retire comfortably. And we've been able to do that. And my concern...
But you also wanted to be sure, I know,
And-
that the people who bought your services also had that same benefit.
Absolutely.
Of a good retirement.
Absolutely. Here's
And
here's
that
what
no
you
one
can-
in your employee would do anything to benefit themselves before that.
Well, we're going to
that
pay a fee to
customer.
somebody to manage this, and there's enough information out there now. You can go on any website with a basically to find out how your earnings are doing every day. You can find out what the fees are. You can find out what the returns are, the yields are, 1 year, 5 years, 6 months, 1 month, 1 day. I can do that now with technology. It's there. So if you're sitting by asleep, I guess you could go to sleep and not pay any attention to your retirement. And I will tell you, me personally, the worst advice I've gotten is the thrift savings plan right here in Washington, D.C., where I've gotten no advice at all. Nobody has ever sat down with me with my retirement plan here in Washington, D.C., and said, what are your goals? Well, I do that with my retirement people several times a year. And that's what those advisors are
It's
for.
working pretty well, though, isn't it?
Not really well, and my earnings
Okay.
outside are much better.
Well, I'm really speaking from a very spotty bit of knowledge here, but I would certainly want to know that someone who was advising me was doing it in my best interest.
Absolutely.
And that they would be required to have all the information they needed to be able to do that. And as far as I know, Mr. Scott, that's what this does? Is it further than that?
It requires you to give advice in your client's best interest. And
Right.
Dr. Rowe mentioned the TSP,
Is there further education or
which
anything
has-
involved, licensing or anything
which has
like
the
that?
lowest fees of anybody.
Uh-huh.
And if an investment advisor told you to take your money out of the stock fund
Mm-hmm.
and put it into an S&P 500 fund, charging 30 times more
Right.
fees, that would not be in your best interest.
Mm-hmm.
And that is routinely done, putting you into to a fund that is essentially the same. If it's S&P 500, they're all the same. The returns are going to be essentially almost exactly the same. And the only difference is the fees charged. The TSP charges 0.029. Some of the cheapest funds out there cost almost 10 times more. The cheapest funds cost almost 10 times that, and some of a lot of them charge 30, 50 times more than that for the same product. Now, you get nick at about 1% a year. All of a sudden, you've transferred from the client to the investment advisor 1% of the funds every year. Well, that's not in the client's best interest. And an investment advisor knows it.
Well, like everything else I do, I prefer to err on the side that I could do the best I could for the people who counted on me.
Well,
Thank you very much.
Ms. Slaughter, would you yield
Thank
to
you,
me?
Ms.
Would you yield to me
Sure,
for
I
just one
would.
moment?
Absolutely.
I just wanted to ask Dr. Rowe, the case that Mr. Scott just described, I advise a client to get out of the TSP, which has virtually zero fees, to get into an S&P 500 fund that has 10% front-loading fees. I find that to be reprehensible advice, ought to be criminal advice. Is there any place in your vision of how this ought to be regulated that what Mr. Scott has described would be permitted?
Yes, and when the bill that Peter Roscoe, myself, and others put together in a bipartisan bill addressed that. You're absolutely right. That's reprehensible to do something like that.
I thank the gentlelady.
Mr. Newhouse.
Thank you, Madam Chairman. I appreciate the opportunity to weigh in on this important discussion. Thank you, gentlemen, for coming with this important issue. Like everyone else on this committee, I too hear from folks at home, amazingly, often on this particular issue, not just from those that are in the business of providing financial advice, but also those that are on the receiving end of that financial advice. So people are paying attention and are concerned with the potential, at least from has been explained to me, of a shrinking ability to get that advice that's so important to folks as they plan for their retirement years. And so I just wanted to say that. I certainly would agree with Mr. Scott that we want to make sure that the bad actors, and I'm sure Dr. Rowe would say the same thing, that we don't want them to be taking advantage of people, that the fiduciary rule should be adhered to. People should be looking out for their best interest. But I'm trying to find out if we actually have a problem here. We have rules in place today, don't we, that cover those bad actors. And so I'm looking, you guys have been here a lot longer than I have, and I admit that I'm still learning, but there's IRS rules that cover certain advice given. There's ERISA rules, if I have that acronym correct. So enlighten me. Is this a solution to a problem that doesn't exist? Don't we already have in place a system that protects those investors? And if we don't, the situation we have today, does it justify another 8 to 10 inches of regulation to solve a problem that may be there?
One of the problems you have is that the SEC does regulate and limits what an advisor can do to a client. The regulation, the difference is that the SEC, for normal investments, has a standard of suitability. That is this investment product suitable for your investment? For your retirement portfolio, one-time thing, it really ought to have a higher standard than that. That is your best interest. An S&P 500 fund with a 1% load, about 30 or 40 times more than we're paying on the TSP, may be, quote, suitable, reasonable. That may be reasonable, but it's clearly not in your best interest to transfer your stock fund and the TSP to a 1% load on a S&P 500 fund, which is essentially the same thing, except the investment advisor can get 1% of your money every year. And so that's the difference. This is a slightly higher standard for retirement funds. Your normal stock transactions will be under the SEC, not the Department of Labor, and you're back to suitability, which is a much looser standard.
Dr. Rowe, do you have a comment as
No,
well?
our bill that we had, Mr. Newhouse, would address that. And certainly, as Mr. Woodall was talking about, no one wants or is going to tolerate these days. And these things do happen where people are taken advantage of. And certainly, we want the best interest, and our bill clearly laid out how that was done. This right here is not going to encourage people or make it more likely that people will save for retirement. That's my concern, is that we have a retirement crisis in this country. When you look at the number of people who are living much longer, which is a good thing, we have to either work a lot longer in this country or plan our retirement a lot better. And I don't believe for 1 minute when you plow through all of this right here, and this is going to be expensive to go through, and what you're hearing these agencies do, we're looking at the rule. Look, they have to obey the law. These companies out there are going to obey the law. They're going to pass on these extra costs to us, though. That's what they're going to do. When I get my cost, it will be more because of this.
So you're saying that there are safeguards in place currently?
And what Mr. Scott is saying, if you have someone, there are financial products out there that cost more, that yield less. You shouldn't be selling those to your clients. It just benefit just you. It should benefit your client also. I don't disagree with that.
Isn't that the fiduciary rule that's in place, though, that says that,
That's
essentially?
right. That's correct.
And I agree with Dr. Rowe. There is a retirement crisis. Used to be people didn't have to go through all this. They retire, you get 1.5 times the number of years, some to average 3 salaries or something like that, and you get a defined benefit. You don't have any calculation. You don't have to be an investment, get any investment advice. You can kind of calculate your defined benefit. Now you got defined contributions where you end up with a lot of money at the end, and it's got to stretch. You got to figure out how to stretch it out during your retirement. How much can you withdraw? What's your investment? How much in stock? How much in bonds? How much in cash? All of those decisions are new. And you're talking about people who may not have opened an account before. This is all they got, and they retire and they got to do something. They're unsophisticated, and that's why the Department of Labor, with retirement funds, I think ought to have a special standard, slightly higher than the SEC normal standard. If you're in buying and selling stock, on a regular basis, you're an investor. You can do a suitability. I guess that works. I'd rather have a higher standard, but this is all you got. You ought to have a higher standard. You ought not be subjected to conflicted advice where, I mean, it's not unusual for everyday workers to have several $100,000 in their retirement fund after 40 years of work, setting aside conscientiously savings, and you could easily get in the hundreds of thousands of dollars, and you walk in, and you would hope that the advisor would be looking out for your best interest, getting you the appropriate products, not drooling about how much fees he can make.
Who in this rule would be the determining party on whether or not advice given is in the best interest of the
Labor Department.
Department?
Labor Department will do that. And here's the problem, that it's more than, it's multifaceted. You have retirement savings out there, but you've also got people you want to encourage to start a retirement plan. And we believe this will discourage small businesses and individuals from starting a retirement plan. Why? Because you'll have, we believe, as has happened in England, less advisors out there, and they're just not willing to set up these very small accounts to get people started. And you need to start the minute you have your first paycheck saving for retirement. The very first paycheck you get, we need to encourage you to do that.
Well, thank you very much. Mr. Chairman, I yield back.
Thank you very much. Both have all, Mr. Polis, excuse me. The
Thank you
gentleman's
so much,
recognized.
Mr. Chairman. I just wanted to compliment our committee, the other committee, Education Workforce, which I have the opportunity to serve on. It's really delved deep on this issue. I was one of over 100 Democrats that had a number of issues in the rule that we wanted improved, and I'm very glad to say that the Secretary really listened to those who had concerns, rolled out a final rule that I think, while of course we're still analyzing it, as are some of the stakeholders, and I do think this is premature, as many of the people that we would trust to go out to have actually told us they're still looking at it. But from the folks who've at least opined back, I believe that this will fulfill the intended goal of the administration, which is to prevent conflicts of interest and make sure that we have the very best standard for our investors without some of the unintended consequences that some of us worried about, reduction of services to lower and middle income families, or where the line was between education and the unrealistic expectation that somebody would have to sign a contract before they could talk. So by and large, those issues have been addressed. I'm sure you can find those, just as we can find those that are happy with the rule, you can find those that are unhappy, but I believe it's a serviceable rule. I believe it will fulfill the laudable goal of the administration. I think it'll lead to new innovation in financial products that are lower cost and higher quality. And it's really the tip of the iceberg for us to address the retirement security needs of American families. It's an important step. But it is a small step, and I'm hopeful that the committee will be able to consider some of the important issues around ensuring that Americans have a safer retirement future. And hopefully with this under our belt, and obviously this will go to the floor, and I fully expect it'll pass the House with very little or no Democratic support, but obviously it'll pass the House. It won't become law. And then the committee can move forward, and the Congress can move forward and work on issues of importance to retirement security for Americans. But I do think it was the committee's process, and even those who probably plan to vote yes on this resolution, I would assume would argue that it's a better rule than the draft rule. In fact, I might as well ask Mr. Rowe that. Is the final rule better than the draft rule from your perspective?
No question, that's true.
And I think that the committee can take some credit for that. And regardless of where people wind up on this final vote, the fact that we have a serviceable rule without some of the ambiguities that people were concerned about, that also fulfills the intended goal of the administration, which is a very important goal and a laudable goal, is testimony to the committee's hard work. And I appreciate both the chair and the ranking member's efforts in this regards, and I yield back.
Thank you very much. Gentlemen, I want to thank you both for being here. Mr. Scott, we enjoy having you here, as you know. I'm sorry I'm not on TV as much with you anymore. I assume you're on TV quite a bit.
Well, Mr. Chairman, if you're not there with me, just not
quite the same.
Not the same thing.
Well, you know,
You got to do some criminal justice reform. I think you
well,
would,
I'm well aware of that, and of course, you know, it's also going on in Texas, a good bit of it.
Texas has done a great deal. As a matter of fact, Mr. Sensenbrenner and I introduced a bill that takes advantage of the lessons learned in Texas.
Does not surprise me at all. Dr. Rowe, your presence here always buoys us. We appreciate your not only confidence that you exhibit, but your knowledge of your subject matter, and we appreciate it very, very much. Thank you very much. This now will give a chance to, if anybody here is to talk about HJ Res 88, the fiduciary rule bill, they should come forward at this time. Seeing none, this now closes the hearing portion of HJ Res 88. The chair will be in receipt of a motion from the gentlewoman from Grandfather Community, North Carolina, the vice chairman of the committee.
Mr. Chairman, I move the committee grant H.R. 4901, the Scholarships for Opportunity and Results Reauthorization Act, to close rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides 1 motion to recommit. Section 2 of the rule provides for consideration of HJ Res 88, disapproving the rule submitted by the Department of Labor relating to the definition of the term fiduciary under a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce. The rule waives all points of order against consideration of joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 motion to recommit. Section 3 of the rule provides that on any legislative day during the period from May 2, 2016 through May 9, 2016, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair and declaring the adjournment. Section 4 of the rule provides that the Speaker may appoint members to perform the duties of chair for the duration of the period addressed by Section 3. Finally, Section 5 of the rule provides that the Committee on Armed Services may at any time before 5 p.m. on Wednesday, May 4, 2016, file a report to accompany H.R. 4909.
You now heard the motion from the gentlewoman from North Carolina. Is there amendment or discussion to that?
Oh, yes, then I do.
Gentleman,
I think
defer
she had one
to
first.
the
Thank you,
gentlewoman.
Mr. Chairman. Yes, thank you. I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 4901 by Representative Spear of California, number 2, which would require parental notification that Title IX does not apply to students in voucher schools and require schools to provide information on where students and parents can seek Title IX remedies. This is a pretty important piece of legislation, since Title IX is one of the most important rules we have in education to protect the rights of students and to keep them safe. So I would urge that everybody would vote yes and make Ms. Spear an order.
Okay, further discussion? Those in favor of the Slaughter Amendment signify by saying aye.
Aye.
Those opposed, no. No. Those have it, noes have it.
Roll call,
Gentlewoman
please.
asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? Mr. Woodall? No. Mr. Woodall? No. Mr. Burgess? Mr. Burgess? No. Mr. Stivers? Mr. Stivers? No. Mr. Collins? Mr. Byrne? Mr. Newhouse? No. Mr. Newhouse? No. Ms. Slaughter?
Aye.
Ms. Slaughter? Aye. Mr. McGovern?
Aye.
Mr. McGovern? Aye. Mr. Hastings? Mr. Hastings? Aye. Mr. Polis? Aye. Mr. Polis? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
The gentleman, thank you.
The gentleman's not recorded. No. Mr. Cole? No.
Thank you very much, Mr. Chairman. If the clerk will report the total.
4 yeas, 7 nays.
The amendment's not agreed to. For amendment or discussion.
Mr. Chairman, I have an amendment to the rule.
Gentleman's recognized.
I move the committee grant H.R. 4901 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Any discussion? Thank you very much. The vote now be on the McGovern amendment. Those in favor signify by saying aye. Aye. Those opposed, no. Noes have it, noes have it.
Mr. Chairman?
Gentleman asks for a roll call vote.
Ms. Fox? No. Ms. Fox, no. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Byrne? Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman? No. Mr. Chairman, no. 4 yeas, 7 nays.
The amendment's not agreed to, for the minimum discussion. Gentleman from Colorado.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for my amendment, the Polis Amendment, to H.R. 4901, number 11, which would require any private school receiving federal voucher funds to provide appropriate services for students with disabilities in compliance with Section 504 of the Rehabilitation Act. And discussion, Mr. Chair. This is important because if there's going to be a program that transfers our public funds to schools that are privately run, and of course there can be privately run schools that districts can contract out or that charter schools can contract out, but in this case they're privately run independent schools. It isn't fair economically if they don't have to meet the learning needs of special education students. And so this would simply make sure that it's a fair economic transaction in that instead of serving a district average of 15% special ed or whatever the district is, a private school and a voucher receiving school might serve closer to 0%, which in effect is an additional subsidy to that school. Since the funding levels are not necessarily commensurate with the needs of the child. So I hope that this amendment is made in order. I hope that it is considered as part of any voucher-type program to make sure that those with learning disabilities have their needs met where the public dollars flow. And I yield back the balance of my time.
Thank you very much. I do have an opinion. The opinion that I have, I don't really need to go through right now because, in fact, it is a question that I'm pleased that the gentleman asked. In my case, my son was bullied in a public school and did choose to go to a private school. It was a private school that accommodated students, and I do very much agree with not only the direction you're talking about, but the availability of that. This, I will tell you, I'm not going to vote for this, your amendment, and it's not as though I don't recognize the importance behind it, but I think it is an engagement, and those who are here from the mayor's office, I would hope that they would recognize that in some perspective, moving that direction would be a very good thing, I believe, notwithstanding somebody that has an intellectual, a physical, or a mental in some way, not trying to exclude anybody or include anybody, but not to exclude anybody, is a powerful thing. It would be for parents too. Thank you for the amendment. Further discussion. Seeing none, the vote will now be on the Post Amendment. Those in favor signify by saying aye. Aye. Those opposed, no. No. The noes have it, noes have it. Accordingly, is there any other discussion or amendment? Seeing none.
I asked him to repeat it because I couldn't hear him the first time.
Well, he makes a very good point, and I admire him for doing this, and I hope I spoke favorably about his amendment with the reservations that I expressed. All right, we'll now vote on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it.
We'd like roll call.
Gentlewoman asks for a roll call vote.
Ms. Fox? Aye. Ms. Fox, aye. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Byrne? Mr. Newhouse? Aye. Mr. Newhouse, aye. Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? No. Mr. Hastings, no. Mr. Polis? No. Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 4 nays.
The motion is agreed to, and accordingly, the gentlewoman, Dr. Fox, will be handling this for
And
Republicans.
I for the minority.
And Mrs. Slaughter will be handling this for Democrats. I want to announce that we do not expect another meeting this week. I want to thank each of us for our working together again today, and to thank our awesome stenographer for her presence. This finishes our work for the week. Thank you very much.